to be considered for Title VII liability, and that would be EBMUD as an entity, AFSMCME Local 444 as an entity, and there's discussion of the failure by the plaintiff to plead any claims that constitute.
Sure. So the normal default is leave to amend.
No, leave to amend would be appropriate. If you look at the entire order, there's already discussion by the court, Your Honor, in earlier passages about how AFSMCME Local 444 is a union, not an employer, and it does not decide who's a supervisor. It does not have.
But it has the ability, doesn't it, to intercede, to request reclassifications, to do all the functions that a union can do when you have I assume a collective bargaining agreement with negotiations between both sides.
In this civil service system that EBMUD has, the classification plan is designed by the employer. This is pursuant to the authority of the Public Utilities Code. They have civil service rules that spell out the classification plan and how it will operate, as well as how to study whether a current classification is appropriate. There's no possible way,
so essentially any leave would have been futile.
Yes, and so what we're asking this court to do, which was an earlier question posed in a case this morning, is to look at that footnote as what it is, which is merely a misstatement of the law because there's an omission of the word individual before the statement defendants. And then to look further and say, on the face of this complaint, the First Amendment complaint, there is no possible way that claims of Title VII discrimination or retaliation could be stated against AFSCME Local 444. It was not in a position to be able to change Ms. Rivera's status. That is something that is done through a reclassification request through the Human Resources Office. This was not about a provision that is in the Memorandum of Understanding, in other words, the collective bargaining agreement. That would be the domain of the union and something the union could be involved in.
Discrimination if you fail to even, for a discriminatory reason, pursue the rights of the plaintiff on the basis of gender, for example.
Not where, like here, there is access exclusively by the employee to the procedure, not by the union.
Just to be clear, if an employee went to the union and said, I think I'm being misclassified, can you help me? The union would say, there's nothing we can do for you, go talk to HR.
I'm not saying that that would be their practice and that there is necessarily a history of that happening here. What we are saying, and on the face of the complaint, it's evident that, and now through the developed record, it's confirmed that it's the employee's right of access to that procedure. The union is not involved. It's not a subject under the collective bargaining agreement. And certainly the union has no ability to determine whether someone's a supervisor.
You may not have the ability to determine it, but I understood her complaint to be suggesting that, or the proposed amendment to the complaint maybe, to be suggesting that the union would be able to pursue a grievance or do something to help the employee, and that if they were doing that on behalf of male employees who complained but not on behalf of her, that would be the allegation she was making. And you're saying that there isn't anything meaningful that the union would be able to do to help an employee in that
That
situation.
is what I'm saying, Your Honor, that there's a fundamental misunderstanding of what the union can do in this particular instance. And on the face of the complaint, it's clear that no amendment could have salvaged her claim. It would be futile to do so at this point. So we ask you to please affirm the order. We also ask you to grant our request for judicial notice because it is important to see those civil service rules showing exclusive access by the employee to the reclass procedure. And they also contain the memorandum of understanding that show that the employee has no right of recourse under the collective bargaining agreement. Do you have any more questions for me? I'm out of time.